The information provided in this presentation and during this webinar should not be construed as legal advice. Attending this webinar does not constitute or create an attorney-client relationship between you and Spillman Thomas and Battle PLLC or any attorney associated with the firm. Material distributed during this webinar is done so with the understanding that the author, publisher, and distributor are not rendering legal or other professional advice on specific facts or matters and, accordingly, assume no liability whatsoever in connection with its use.
Everyone's coming in. My name is Shane Riley. I'm the chair of the Intellectual Property Practice Group here at Spillman Thomas and Battle in our Pittsburgh office. And today, what we're going to be talking about is artificial intelligence, particularly generative AI models, and copyright law, how that is affecting copyright law, both in terms of registration and enforcement in the courts, and some other issues that pop up along the way. Today's presentation should be only, 30 minutes max, probably less than that. And it's meant to just be a pretty broad overview of what's going on, not too nitty gritty. And I hope to end up with some takeaways for all of you moving forward in your own work. So to get started, with an overview, today I would really like to focus on answering three big questions that are going on right now. First, what are the copyright law and policy issues with generative AI? How is this affecting everything? What are the questions that are being asked? What are the debates that are going on in the public forum? Where is this all going? Second, what is the response to these issues so far? And I'm talking about what is the U.S. Copyright Office saying? What are the courts saying so far? What is Congress doing so far? Where's the debate? And then also, like I said, what can you do to protect yourself as a user of AI and a copyright holder? So whether you are interested in using these AI tools to generate new content and you're worried about the implications of that, or if you yourself have a lot of copyrights and you're worried about how they're being used to train these AI models, I want to talk about what you can do to protect yourself moving forward. So a little bit of background on AI. I think everyone has had some sort of interaction with AI at this point online. It's obviously boomed in the past few years, especially during and after the pandemic. But these technologies have been around for a while, and they've been just improving and improving over time. So things like ChatGPT and Google Bard, these are used for text generation. I think a lot of people have had interaction with these tools, but there's also a bunch of others like Midjourney and Dolly, which are used for images, Meta Make a Video, which is for videos, and then MusicLM and MusicNet for music. And this is just a very short list of many AI algorithms that are out there that generate some sort of content. But what it's really falling into is these categories of text generators, image and video generators, and music generators. And that's what's having the biggest impact in the copyright space. So all of these technologies are considered large language models, or LLMs. And they basically work by putting together a large data set that is used to train an algorithm on predicting text and generating outcomes that are like what you put in. So through the training, the AI is learning patterns in language, for instance, with a text model, and then using that to extrapolate those patterns and create wholly new content. So it's not just carbon copied content that is posted together, but it is an algorithm that is meant to take content and then act as if under certain parameters they were that author and produce something else, or produce something that is just responding to a prompt. It can take a lot of different forms, but it's basically that large data set being fed into an algorithm and spitting out some sort of content that is meant to mimic the content that went in. So the data sources can be from all over. They can be purely public domain sources, meaning everybody has free access to them. No one owns a copyright over them. It's really easy to get access to them. That can come from AI-specific license data. So we'll talk about this a little bit throughout, but essentially licenses for copyrights now that you're getting from large, copyright representative services are including AI specific provisions or excluding AI specifically from the licenses that they're handing out. So some AI companies are going to be going directly to sources and getting license data so that from the jump, they know that they're not going to run into any copyright issues. And also the largest kind of box of data sources seems to be coming from copyrighted works that are scraped from the internet. So these are companies that are just going out on the internet and they're not really being careful of whether or not something is copyrighted. And we'll get into why they're doing that, but they're just trying to get everything they can from the internet to feed into the model so that they can train it to do whatever it is that they want them to do. Now, this training can be supervised or unsupervised. Supervised typically means that there's a human in there that's trying to correct the model as it's learning so that it develops an algorithm that behaves the way a human would. This is how you get really high quality outputs from AI that mimic human behavior or human speech, is because typically in those instances, humans are directing it. A human would respond this way, and then it continues to learn off of that. So, and then an unsupervised model would be a little bit messier. It would just be, it's taking the text, it is making its own extrapolations, it's making its own predictions, and then it's pumping out a product. So typically the highest value AI programs are going to be supervised training, and they're going to be using a high quality data set. Because the base rule for AI generation is quality in equals quality out. If you're putting in high quality sources that the model can learn off of, the output that you're getting out is going to be just as high of quality, or it's going to be more convincing that it is human generated instead of machine generated. And because of this, that is why AI companies that are developing these tools are very interested in copyrighted content, because copyrighted content has high artistic value, expressive value. And if they can train AI on that type of content, then the content that you're getting out of it is also going to be expressive and high quality and useful. So that is really where the background of this comes from, is that AI companies want to use copyrighted content, and content creators are very concerned about having their content used to train AI models. Which leads us to the first question of what are the copyright law and policy issues with generative AI? So there are going to be both input issues and output issues. The input issues are about the copyrighted material that's going into the model. So like I was just saying, is there infringement if the material that you're putting in is necessarily copied if it's used to train the model? Content creators are saying yes. AI companies are saying no. So that's one issue that we're dealing with. Another is with the output. So this new content that is created by the model, is that a copy, or is it substantially similar enough to the original content for it to infringe on that content's copyright? And that's going to depend on the circumstances, because sometimes what is coming out, it has little pieces of copyrighted content in it, or maybe some exact phrasing into a larger paragraph that has new phrasing, or sometimes it's a completely new product that's coming out that just is in the style of. And most of these AI companies are claiming that the goal is really to generate completely and wholly new content that is not copying anybody else's content. So that's an interesting area of the debate. We'll continue to talk about that in an infringement context. Also, another issue with output is just the copyrightability of AI-generated content. So, companies are really putting a lot of money into training these AI programs and models. And they want to own that content in a certain way. And sometimes that's going to be, contractually stipulated between the AI platform and the person that's using it, or the company that's using it. and sometimes they're going to want to claim all of it. But what it has generally presented is this question of, when AI is doing the work, can you even copyright it at all? So with the infringement issues, you know, using copyrighted materials without a license for commercial gain is going to be considered infringement. So that's the classic case of infringement, is that you have a valid copyright and someone has copied it without your permission. From there, that person has to claim some sort of defense, which is typically a fair use defense. So if a company is taking a copyrighted work without permission and using it in their AI model, there is necessarily going to be a copy made. And that is the basis of a lot of these lawsuits, is that a copy has been made on a validly copyrighted work. Therefore, the burden shifts to the AI company to make a defense for why it isn't infringement. But what the AI companies are also saying is that the output isn't necessarily an exact copy. So just because a copy is made during the process of training the model doesn't mean that the content that is created is itself a copy. But that is also going to depend on how much, again, like, are there portions of it that are exact copies, or is the work so derivative that it's substantially similar that it's going to be considered infringement? It's going to be a sliding scale depending on what the actual prompt is. And in a lot of these cases, the content creators are finding prompts that are likely to get a copied response so that they can show that the AI is just copying. But an entirely different prompt could give, wholly new content that has no part of the original work in it. So it can be interesting to see how it varies across the field. But in all of these cases where an AI company is being sued for copyright infringement, they're claiming a fair use defense, which has been, the classic defense used by researchers and educators and anybody that's working, at the edge of innovation, saying, we need access to this copyrighted material to move the needle forward in this technology. It's for the greater good. It's not necessarily for commercial profit. We're not just selling copies of copyrighted works. There's another reason for it. But in each case, it's always going to go through the same case-by-case analysis, where the courts are weighing 4 different factors on whether or not it's going to be considered fair use. So the first factor is then the purpose and character of the use. Was it transformative? Did you take the copyrighted work and turn it into something that was completely different and not just a copy or a derivative of that original work? Is the purpose for education, which is a classic fair use defense, or some sort of other nonprofit, non-commercial purpose, or was it for commercial purposes? The nature of the copyrighted work, how creative was the original work that you copied from is gonna weigh into it. The amount or substantiality of the portion used. Again, how much of an influence did the original work have on the output of the AI model? And the effect of the use on the market or the value of the work. So is the AI content that is produced by this lowering the value of the original work? A lot of these content creators are saying, yes, it does. It's creating competition for human-generated content, or it's taking, one original novel, for an instance, and then creating an entire series maybe based on that novel. And that is really devaluing the original author's market for their continued works, because once you create something, if AI is allowed to just transform it into something else and then produce, X amount of copies of it, they're getting the real value of it while using the original work to base it off of. So moving on to the copyrightability, and I see apologies for my pause. I see that there is a question, so I'm about to get to it and hopefully answer it. Um, so the next main issue, we just went through infringement. Now it's the copyrightability of AI generated work. So the Copyright Office and copyright law has established for a long time that the authors of copyrightable works must be human beings under US copyright law. It has nothing to do with the creativeness of the product, the content, the work at all, what type of work it is. It's merely an authorship question. Is the author a human being? If not, then it's not going to be copyrightable. And I think that, a few years ago, and I'll get into this again when we go through some case examples that are going on right now. I think one that people remember from about 10 years ago is there's a photo, it's a selfie taken by a monkey, and it caused, a lot of news stories about copyright law, and the photographer, or the person that owned the camera, I should say, was trying to claim a copyright for that work. And the Copyright Office denied the registration because he didn't take the photo. The monkey took the photo, and an animal can't hold a copyright under US copyright law. So it's really, been well established that it has to be a human being. So where we get into the issue of copyrightability with AI generated works is that there's usually a mix. So you'll see that most works are going to fall onto a spectrum. There are going to be works that are fully AI generated, that if there's been no human involvement, the Copyright Office is going to make a very clear ruling on it to say that this was not generated by a human, therefore it is not copyrightable under US copyright law. But compared to the other spectrum where something is entirely human generated, we're entering a period of time now where AI is usually involved in some way. Even if you're just using a search engine online, you are technically using artificial intelligence to a certain degree, because these algorithms all have AI components to them now. So did you use ChatGPT to spit out a list of ideas for an article or ideas for a novel? Specific music works that you want to listen to influence you to create something else that you're feeling. It can be used in a lot of different ways to just get the juices flowing, get the creativity flowing. And that type of use is probably going to be considered, just like anything else, reading articles, ingesting information, getting ideas. If it's not part of your writing process, it's probably not going to be considered very influential to whether or not you're going to be able to get a copyright on it. But then you kind of move into the zone of, did you use it to create certain parts of the work? And then, we'll talk about this in some case examples in a little bit, but what the Copyright Office is moving towards is kind of basically making you, in your application, tell them which parts were human generated and which parts were AI generated, and then they're going to grant registrability on the human generated portions and make you disclaim the AI generated portions. So it's kind of a sliding scale depending on how much it is relied upon. And as I say here, the more you rely on AI, the more you're going to have to disclaim at the end, and the less you're going to be able to enforce that copyright against other people using it, because if it is determined that AI made it, then it's not protectable in any way, and it will then be public domain for other people to use. Another issue that comes up is ownership. So we're not going to talk about this too much because I want to get to the case examples, but this is about, who owns the output of an AI model. Is it the platform creator that trained the model and, developed it and put the money into it? Or is it the platform user that put the prompt in and really crafted, what the output was going to be specifically? So that's kind of an ongoing debate, and you're going to see it pop up typically in the contractual terms of the terms of use with the platform. Sometimes these companies, they want to keep the content. They want to at least use the content that's being created to further train the model. But they are saying, whatever you do with it, is yours. That's also a way for them to get a little bit away from liability, is that, you know, they just train the model. They're not the ones that are making this output. So if it's a question about the output, you have to go to the user. So that's also an ongoing debate, is, you know, who truly owns this and who's really liable if there is infringement going on. Some other issues that pop up in this that I just want to mention are name, image, likeness, publicity rights, and unfair competition. So this is where artists are concerned that AI models are going to be able to you know, mimic their voice. You see this with actors a lot, mimic their voice, mimic their likeness, and that, you know, a Hollywood studio is going to be able to get one capture of an actor and then be able to reproduce their likeness in, you know, a million movies for the rest of time. So that's a big issue around generative AI. It's not a copyright issue, so I'm not going to really talk about it much more than this, other than mentioning that it's out there, but it is definitely a concern. What you need to know is that these NIL rights, publicity rights, they tend to vary by state, with the strongest being out in California, for obvious reasons. But you know, that's really a state by state approach, and it's yet to be seen. You know, NIL rights are coming up in a lot of other spaces like college sports. It's yet to be seen if there's ever going to be some sort of federal treatment of that. So moving into the second question, what has the response been so far? So obviously, the Copyright Office is very aware of these issues, and they're currently working on it. 2023 was a pretty big year for them in moving forward with some of these AI issues. So briefly, they put out a registration guidance for anybody that is currently filing applications. They have a new website where they've coalesced all of this information on AI that they're updating all the time. Last summer, they did listening sessions and webinars, and most recently, they put out a public notice of inquiry to ask the public for comments on these issues so that they can put a report together for Congress. The registration guidance just reiterates the long-held history of, you know, recognizing new technology to generate work. So they require human authorship, but they ask this question. I'll read this quote. Evaluation begins by asking whether the work is basically one of human authorship, with the computer merely being an assisting instrument, or whether the traditional elements or authorship in the work, literary, artistic, or musical expression, or elements of selection, arrangement, etc., were actually conceived and executed not by man, but by a machine. And this quote is from 1965, if you can believe it. So at the advent of computers, when not a lot of people in the public really understood how computers worked or what they would eventually come to be, the Copyright Office was already ahead of this, saying, you know, we understand that technology is going to advance, there's going to be new tools that are used, and that does not necessarily mean that you can't get a copyright for it. Just because you use a computer to write a manuscript doesn't mean that the computer wrote the manuscript. So they do understand that there's always going to be this evolution of technology that they're going to have to keep up with. And that's what they're recognizing so far, is that AI does not mean that it's not copyrightable. It's just something that needs to be looked at closely. So the registration guidance says that there is now a duty to disclose the inclusion of AI-generated content when you're submitting your application. So just know that if you are interested in submitting applications, that you need to disclose whether or not you used it. That's not going to be determinative of whether or not you get it. And then if you use it more than de minimis, so like I was saying before, if you're using it beyond that just kind of brainstorming, throwing things around stage, that content is likely going to have to be disclaimed ultimately before you get your registration certificate. So briefly on the notice of inquiry, the Copyright Office put out this notice of inquiry in the fall. It closed just before the holiday season. So they're currently digesting all of that and putting a report together. And they asked a lot of different questions to the public that basically kind of fell into these four broad policy concerns that I've been talking about, which is just the use of copyrighted materials to train AI models, copyrightability of material generated using AI systems, potential liability for infringing works generated using AI systems, the treatment of generative AI outputs that imitate the identity or style of human artists. So I've touched on all of these before, but just know that they're currently working on it. So before we end, I just want to go through a few cases that are going on out there right now. First, we'll start with some registration cases. So the most kind of famous so far, this came down last year, was Thaler versus Perlmutter. And this is where a content owner, I should say, claimed that his AI algorithm creativity machine, I'm sorry, was the author of this work. And you can see the work here. It's called A Recent Entrance to Paradise. This is a completely AI-generated image. It has not been touched by a human at all. And this, like we're saying, is on that far end of the spectrum where it's very clear, and the DC District Court upheld the Copyright Office's rejection of the application because there's no human authorship here. So this was, Thaler was really trying to make a point of, we should allow copyright for AI-generated works, and the Copyright Office and the courts have said, no, we're not going to do that. That's a bridge too far, at least right now. So a little bit more of what you're actually going to see is evident here in Castanova's Zarya of the Dawn. So this is a graphic novel that was written by Castanova, but all of the images in the graphic novel were generated by AI. So in this instance, the Copyright Office said that the text and the arrangement, selection of the images, that was all registerable and copyrightable to Castanova as a human being, but the actual individual pictures themselves were not copyrightable. So this is where we're going with these applications, is that there's going to be a certain portion that is human generated and or reflective of human expression that is copyrightable. And then there's going to be an AI generated piece that you're not going to be able to enforce copyright on. So you can take the images out of this graphic novel and use them for your own purposes without, risking copyright infringement from Castanova. So moving into some of the court cases, the biggest one that's going on right now, because it was just filed at the end of the year, and it's the biggest players in the space, is New York Times versus OpenAI and Microsoft. So New York Times is suing OpenAI and Microsoft for using all of its copyrighted content to train essentially ChatGPT, but it includes other AI models as well. And that ChatGPT is using these to mimic the New York Times, and at certain times regurgitating verbatim Times content. So in this case, OpenAI is taking the innovation approach and saying, this is absolutely fair use. What we're doing here is we're transforming this into something else. It is for the greater good. It is for, pushing this innovation forward. The output is typically original, but it has bugs. They do recognize that sometimes it is pumping out like an exact copy of what the Times content said, but they are working on it, and they don't want that to be, ultimately what the model is. So while recognizing that, they say that what they're really concerned about is what about the original content that is coming out of it. And they're really relying on this Google Books precedent, which is basically Google Books puts a lot of content online that is otherwise copyrightable for, a nonprofit kind of library purpose. So that worked out for them back when that was decided. And now AI is trying to use that model to say, like, we're basically doing the same thing. We're using copyrighted material, but we're not using it for commercial purposes. Well, New York Times is saying you are using it for commercial purposes because you are ultimately selling this AI model, and you're selling the content that comes out of it sometimes. So there are commercial aspects to it. It's not completely, nonprofit, educational, and it's not pure. So this really frames the current debate on what's going on here. New York Times represents copyright holders and content makers, and OpenAI is representing innovation and AI and saying, we need to use copyrighted content in order to push this forward, and we shouldn't have to pay for it. is the other thing they're asking for. So in this case, New York Times is seeking billions to possibly trillions of dollars in damages. So it's going to be really indicative of how the courts are going to take this moving forward. Another one to briefly mention is Anderson versus Stability AI. This is where illustrators have sued because their images were used. So I just want to bring this up to let you know that it's not just text, it's images. This one is currently working its way through. They just filed a new amended complaint in November. Parts of it were dismissed. Some of the plaintiffs that brought claims didn't have federal registrations, which is required for bringing this. So that's another tip I'll have for you at the end is get registered if you have content. Another similar one is Getty Images versus Stability AI. It's very similar to Anderson. I want to bring this up just because it's happening both here in the US and in the UK, which is interesting because UK has different copyright treatment, but it's very similar and there's a lot of harmonization worldwide. That's always been the goal with IP is to move towards global harmonization because the lines in a global economy with the internet become very blurred. So it's going to be interesting to see what happens both in the US and the UK. In this instance, it's also interesting because Getty, owns all of the images that are in their database, and they also have their own AI product that is trained on their images. So it's not this kind of purely pro copyright holder argument. It's also for their own commercial benefit. They want to be competitive with AI and they don't want them using their content. So it's going to be interesting to see how that one goes. So moving forward, what's next? This is all to say that this is all really up in the air right now. The courts still have to make some determinations about how far they're willing to let AI use copyrighted material, how much they're going to stand behind copyright holders. It's going to be some sort of balance at the end. And I think as more people get more knowledgeable on this topic and copyright holders are more aware of their rights and how they can enforce, I think AI specific copyright licenses are definitely going to be on the rise. It's definitely a good idea if you don't have deep pockets like Microsoft and OpenAI to defend yourself from these lawsuits, to make sure that you're only using licensed content in your AI model. But it's definitely yet to be seen. Congressional response, I think, is not going to happen anytime soon. That's for sure. There are some reports out there. Senator Schumer has a framework out there. It's all very broad. Everyone in Congress is aware of the impact of AI, but I think they're very wary to take any sort of actual action before the courts decide and before the USCO issues more guidance on what they would like to do. And that's likely, if there is legislation at the end of the day, it's going to follow these court decisions and it's going to follow the Copyright Office guidance. So before we go, our last question: what can you do to protect yourself as a user of AI and a copyright holder? If you want to make or use AI generated content, so if you're on more like the OpenAI side, you want to be able to use this type of stuff. It's good for your business. It's best practice to obtain permission from copyright holders. If you have permission, if you have a license to use it, then they're not going to be able to claim infringement against you. So it's always good to just get express permission. You can also, depending on what you want your AI model to do or what you want your AI content to be, is to only use public domain materials for the training set, or to use an AI model that has only used public domain sources for training. You want to question your AI vendors about that too. Like, what liability are you signing up for if you're using OpenAI's platforms to generate content? Are you going to be sued for copyright infringement, or can you be pretty well assured that either they are taking over all of the risk through the contractual terms of your arrangement, or that they have only used public domain sources or licensed sources to train, so you don't have to worry about it? Another thing, you want to get AI disclosures from your content creators. So if you have employees or freelancers that are making things for you, it's good when they're submitting them to you to have them answer questions about the involvement of AI. Because you don't want to be liable without even knowing that your freelancers are using AI to generate all this content. It's infringing on copyrights, and then you get hit with a lawsuit. So disclosure, disclosure, disclosure. You also need that to file the application anyway. So it's a good thing to get that out of your content creators. Now, if you have copyrighted works that you want to protect, you should be, reviewing your licenses. Are you making sure that they're not allowed to by contract, and even reminding them like, hey, just so it's a little provision in this contract, but you do not have permission to use this in an AI model, so do not feed it to one. You can also set up online policing systems for looking for pieces of your copyrighted content online. There's a lot of different companies online that do this. They embed your images and text with copyright information management data, and then they use that to track it. So there are ways to have this kind of monitored on a broad base. You can also use cloaking technology. These are a little bit newer, but Glaze is one that I found. And this disrupts data mining. So it embeds information into it that kind of throws off an AI model. So it's interesting how the space is kind of engineering itself to shift as this becomes more and more of a reality. And the last piece of advice is just file your registration applications. If you have copyrighted works, not to get into the whole history of copyright, it's inherent in the work, but if you want to file a federal lawsuit, you have to have a federal registration. So there's nuance in when we can do that in terms of, when the infringement occurred and when you want to file your lawsuit. But the basis is you're going to get thrown out of federal courts unless you have a valid copyright registration. So if you have any questions about that, obviously reach out. Everyone here at Spillman is happy to help you both by answering questions and getting those applications filed for you. So with that, I went a little bit over, but if there are any questions, feel free to put them in the chat, speak up right now, or I put my contact information here. Always feel free to read. Yeah, so Drew's question was, in regards to copyrightability, has anyone challenged whether AI generated material qualifies as works created via an authorship, or if it constitutes an original expression? So it's not really an either or. It can be considered an original expression, but they're categorically disqualified from being authors under US copyright law. So the Copyright Office, the course, they don't really want to acknowledge authorship by AI, other than say that if there is no human authorship, then it's not copyrightable and is therefore a public domain. So that's really where it is right now. Obviously, AI generators are debating this. They want AI in certain circumstances to be considered the author, because then that will mean that they then own that and they can enforce the copyright against others. So that's definitely part of the debate, but the courts and the Copyright Office have been very clear that a human has to be an author for it to be registered. Okay, well, I don't want to keep anybody too much longer. Like I said, if you have any questions, if you are interested in getting any copyrights registered, or if you have any questions about your application or the use of AI in generating works, please feel free to reach out to me at my email or my direct line. And thank you so much for coming. Have a wonderful day.